I just gave it a couple more minutes there just for payroll agents and all the various people that might be involved in completing the form. So that's why today we wanted to give you a quick run through and help show some complex areas and some common problems. So if I can move to the agenda for this morning. After our introduction, we're going to look at what does Hmrc want to know. So why are they looking at these returns? Why do they want this information compiled for the share plans? We're then going to move on to points to note on reporting with Hmrc. So some specific areas to note and some areas of concern and some common pitfalls. That leads on to penalties, a word no one likes to hear. And I can set out for you some of the penalties that are due and also some of the wider considerations around what will happen if you file an inaccurate report or you file it late. We'll then move on to Shareplan Registration, as you can't file an annual return until you register your plan. And the 6th of July is also that deadline for many of the Shareplan registrations. So we'll take you through that process briefly and hopefully that can show the things to note and the steps that need to be taken in order to reach that annual return. EMI plans, which many of you may have a specific extra step that other plans don't, and that's the EMI notification of grants. And so I'm going to go through that separately because that's different to the grants of any other shares or other options other than EMI. So it's a specific step for EMI, and that's why we'll be taking that point there. We'll then move on to the ERS annual return, which is the return for any shares or options that you've awarded to any of your employees or employed directors in that particular tax year. And then also we'll have hopefully time at the end for Q&A. And you'll see that there's a Q&A function on your screens, and please do feel free to ask questions as we go along, and I'll try to answer them. To the extent that I don't, I will come back to you after this seminar. So let's start with, what does Hmrc want to know? So this is all reporting for share plans for Hmrc are to do with all UK employee and employee directors, any securities that they hold. Now, securities is a wide definition, and it's not just shares and options. But for the purposes of this webinar, we're going to be focusing on shares and options. But it's important to note that it does also cover things like loan notes. But for the purposes of keeping this simple and for what most companies are looking at, it's shares and options. Now, all plans need to be registered with Hmrc. It's the starting point. It's so they have it on their radar, and then that is then used to tally up with any returns that might be coming in from each year going forward. And also specifically for the tax advantage plans, it will secure the tax relief. So this is critical if you have a tax advantage plan. By tax advantage plan, the most common is EMI, the Enterprise Management Incentive, but it also covers CSOP, which is a company share option plan, SAYE, which is Save As You Earn, and SIP, which is the share incentive plan. So if you have any of those, that's a tax advantage plan. They have to be registered by the 6th of July following TY, that there is a tax year, following the tax year, but they're established. The exception to that is EMI, which needs to be registered sooner than that in some circumstances. And we'll come on to that when we look at the notification of grant. Non-tax advantage plans are, for example, something like growth shares, which lots of people might have heard of and may have. But also any non-tax advantage options, which used to be called unapproved options, and any other general share arrangements or option arrangements that don't fall within those tax advantage plans. Now, these have to be registered too, and that's something not everybody always realizes. It's not just the tax advantage plans, it's other share arrangements such as growth shares or fully taxable options. Now, the 6th of July is not such an important date for the non-tax advantage plans. The first time that they need to be registered is when there's a reportable event. An example of that being the grant of an unapproved option. You can set up, say, a fully taxable option plan or a growth share plan, but you may not actually issue growth shares, or you may not actually grant an option for a while. It's only once that's done that you need to register it. Now, another thing to note, and this is where a lot of people get caught out, is that the registration doesn't apply to just official share plans. So some companies, you may think, oh, I don't have a share plan because I don't have Company X Limited share plan written on a piece of paper and participants in that sense. But it covers any type of employee equity. So a one-off award maybe to a director who needs to be incentivized. It might not be under an official plan, but it's still an award of shares to somebody that's employed in your business. And by virtue of that, it's what we call an employment-related security. It's an option or a share by virtue of employment. Now, when we come to the annual reporting part of this webinar, I'll explain a bit more about what is an employment-related security, because the definition is quite wide and far, and also spans quite a long time period. So we'll move on to that in a slightly later. This also covers gifts, maybe to an employee as well. So it's not just an official share plan, and that's something to note. And of course, if anybody has concerns, that's exactly why we're here at Gannons, to be able to help with that, because you may not be complying with the Hmrc reporting requirements without realizing it. Now, another important part of the registration process for certain of the tax advantage plans is that Hmrc will be asking you at that registration point online to self-certify that the plan meets the requirements of the legislation. This is for the plans that are not EMI. So therefore, plans that are the CSOP, the company share option plan, the SAYE plan, and the SIP, the share incentive plan. Now, that's normally why companies come to advisors to make sure that they meet the legislative requirements, because Hmrc will require that self-certification. This is in lieu of when Hmrc used to give their approval, and it used to be that you could write into Hmrc that the company meets all the tests for those share plans. It's only for EMI now that Hmrc do that. And therefore, it's really critical that you have to self-certify as part of the registration process. And therefore, timing on this is important, because you need to make sure that you've done all your registrations so that you can meet the requirements before you grant any awards under these plans, so that you can be sure that everything's done and the tax relief should be available. If the plans are not registered by the 6th of July for most of them, then those tax reliefs will not apply. And that's quite serious if you're telling people that you're giving them a tax advantage plan and actually it's fully taxable. So again, those are the kind of issues that we look at here at Gannons to make sure that things are being granted in the right way and in the right time. Now, if we now move on to points to note. So these are some good points to just bear in mind when we're looking at the reporting requirements at Hmrc. And this applies to not just the registration of the plans, it also applies to notifying EMI grants and also to the online annual reporting. So these are across the board things to look at when you're dealing with Hmrc annual share plans. First of all, check Hmrc have the correct contact details. The Hmrc tends to still correspond with posts on certain things, which can seem archaic. But when you're waiting for certain activation codes, which you may require in order to register your plans, if it's gone to the wrong address, then you might be in difficulty, especially if you're leaving things short of time nearer the 6th of July. So I can't stress enough, the sooner the better, basically, with your reporting. If you leave things too late, you could be in trouble and miss that deadline. Next thing to consider is, do you have a payroll agent? I know some companies outsource their payroll. Now, this is important because the payroll agent can't report on share plans. So you may have to set up a separate portal with Hmrc to make sure that you have the right codes for the right people to be able to do reporting. Now, who can report? So the company can report, or you can appoint an ERS agent. For example, here at Gannons and other companies, agents can be appointed to report. There are various steps that have to be taken, and if it's something you're interested in, we can speak to you about that. But generally, it's we here at Gannons guide the company through, and the company does their own filing with our assistance. Now, if you are a part of a group, it doesn't need to be that the parent company of a group does the reporting. It could be at the employer level. So it very much depends the best placed company in your group to do the reporting. Now, one of the reasons why it's so important to get all this reporting correct, apart from the potential loss of tax relief, is that Hmrc are increasingly looking at the correlation between Shareplan reporting, what you put on your payroll in terms of taxes deducted, and any corporation tax deductions that may have been claimed. They're increasingly bringing these together to see if there are gaps. So, for example, if you have a non-tax advantaged option, they want to check that you have correctly deducted the income tax from the payroll for those individuals. So it is very important. The other thing to note, which I haven't actually put on this slide, is if you have internationally mobile employees. Now, it may be that for most of you, this isn't a consideration, and it's something that I can discuss separately with anybody that does have that concern. But there are situations where you may have a UK employee who is traveling abroad for a certain part of the year with an option or a share that they've acquired through their employment. There may be certain events that happen, which mean that there's an apportionment of the time that they spend whilst they hold this award, and it may be taxed in various jurisdictions. So the time spent in the UK will be part of that, and then it could be time spent in the Netherlands or America. All those different tax jurisdictions will be looking to take a piece of the pie, and they may all have their own reporting requirements. So it's not just the UK to consider. Equally, if you have employees that are holding awards and are spending time in the UK, it's also something that needs to be looked at. So I'm not going to focus on it for this webinar, but if you have internationally mobile employees holding awards and you're concerned about that, you can come and speak to us about that too. Now, what happens if you get any of this wrong? Not just the registration, but the annual return. Now, there are penalties for late or incorrect filing. It needs to be substantive material in substantive failure to put the right information on the form, but it is something that Hmrc look at. Last year, they accepted COVID-19 as a late filing excuse. There's been no evidence that that's going to be applied this year, so do look at 6th of July as a drop dead date. Moving on to the penalties. So these may not look like huge fines, and I appreciate that. The main point is my last one, which is the main risk is that you have increased attention from Hmrc. So although you may feel as a company, I can deal with a £100 automatic penalty for missing the 6th of July deadline, bearing in mind, as I say all the way throughout this, you might lose your tax relief as well, which is also a much bigger point. You're putting yourself at risk for an Hmrc that you'll be much more on their radar, and there'll be other things that they can open up. So that, for me, I'd say is the main risk here, the increased scrutiny from Hmrc, rather than the individual fines, which, as you can see, until you get up to 9 months, where there could be daily penalties, which I have never actually seen in practice, but in theory they can be applied. It's more about the increased intention. So that's for late filing. For inaccurate filing, which has to be material, it can be up to £5,000. And again, it's that increased attention that Hmrc can look to open up wider inquiries that it should be of concern. So the registration of the plan. This is just going over again what I said before about the types of registration. So when you go onto your portal, you'll notice that Hmrc have different types. So they'll have a different form for EMI, a different form for CSOP, a different form for SAYE, and a different form for SIP. Non-tax advantage, this is important, comes under a tab called Other. it's not immediately obvious. This is because they scoop up all the other types of arrangements other than the tax advantage ones, and they call it other. Again, this is something that we can help guide you through, but we just wanted to highlight the main points here so that you have it for your consideration. So you need to register as your plans, as mentioned before, in order to file your annual return. So that's why this step is so important. That's why I wanted to talk about it first on this webinar. And as said before, you need to self-certify or notify your EMI options, which we'll come on to, in order to secure that important tax relief for the plans that are tax advantaged. Now, if you need to go through the government gateway and you don't have the ID, you can apply for it, but you need to get a reference number, activation codes, etc. They can all take time. So once you've actually registered your plan, you'll get another reference number, and this can take 24 to 48 hours to be generated. So don't register your plans on the 6th of July. Do not leave it that long, because you may not get your reference number in time and you may miss that deadline. So I just wanted to show you now a bit like what the portal will actually look like. So once you come up onto the ERS online, this is the page you'll have once you need to register your schemes. So the ERS online service is part of the PAYE portal. So if you have PAYE details already, which is a government gateway ID and password, then you should be able to get onto the portal and you'll see a section that says ERS, and that's your employment related securities. Once you go into that, you'll be able to view your schemes and arrangements, which is a page like this will show. If you don't have that government gateway ID, you're perfectly able to apply for it. But again, that's time that will take to apply to get that reference number in order to go in and then generate another reference number, because Hmrc are quite keen on these numbers. Bear in mind, all this takes time. And so again, we're on the 1st of June now. We have time to be able to make sure this is done right now. If you start thinking about it, and if you need Gannons' help, obviously we're here. But don't leave it too late, just in case registrations are needed that you didn't anticipate. So that's a Shareplan registration. I've been talking about the EMI notification of grant, and I just wanted to bring that up here first, because EMI requires an extra step to secure generous tax reliefs. So unlike the other tax advantage plans, where it's just the registration of the plan by the 6th of July, EMI, you need to actually notify the grant of those options to secure the tax relief. Now, you have to register the plan first to be able to register the grant of the EMI options. And the EMI options must be registered within 92 days of the date of grant. So the 6th of July isn't so much a date for EMI. EMI is a much more immediate requirement to register the plan, because overall you still need to be able to notify the grant of the EMI option within 92 days to Hmrc. And that's from the date the option was granted, not the date the plan was registered. So we recommend always to our clients that as soon as you grant your EMI options, you register your plan and you notify Hmrc in that order, in order to make sure that 92-day deadline is not missed. This isn't a requirement for any other type of plan. For all the other types of plan, the grant of the options or shares are on the annual return, and we'll move on to that. So it's just EMI critically that has this extra step. For everything else, it will be on the annual return, which is due by the 6th of July, and we'll be moving on to that shortly. So the annual return. So I want to take this opportunity to just talk about ERS a bit more. I said earlier that I would describe in a bit more detail what an employment-related security can be. So it's generally the shares and options. It can be loan notes, it can be bonds, it can be other things, but it's for any employee, UK employee or employee director. And it's also interesting with the time period it covers. So it covers former employees and potentially future employees. And this is a big trap that people often fall into. Just because somebody is currently employed with you holding securities, it doesn't mean that you might not have to report on your annual return events after they left employment. Now, typically, shares and options are taken off people when they leave a business, but not always. And so this is very important to note. If you feel that there are people that you may not have reported correctly, we can go back and that can be looked at. Hmrc are at the end of the day an information gatherer at best. They'd rather get the information late than not at all. But this is a trap that people fall into because it can look back 7 years. Yes, I did say 7 years. It's quite a long time. So if you've got people that have been an employee within 7 years of the date today, and they are holding what you think might be employment-related equity, there may be reporting obligation on the company. If you think that that's something of concern, then we can obviously help you look into that. It can also capture potentially future employees. What Hmrc are trying to do with this is avoid a situation where a company may say, I'm going to grant you a share and I'll make you a director tomorrow. So I'll grant you a share, I'll grant you an option, sorry, I'll give you a share today, and then I'll make you a director tomorrow. Because today, technically, it's not employment related because you're not employed. Hmrc won't accept that. So there's not a definitive period of time like the 7-year look back for former employees, but it's a sort of reasonable time. I tend to, from practice, feel it's around 2 years. But it's not necessarily defined. It's on a case-by-case basis to look at the arrangements in place. Was it in the party's anticipation that this person was probably going to be employed at some point? If so, it will be probably seen as employment related. Now, the connotations of that go wider than reporting, but that's not one for this webinar. But obviously that could mean that there's tax due, employee tax. So if you think that that's a situation as well that may be of concern, again, please do feel free to get in touch about that. Now, I just wanted to give you an example. These are the links, and you will get a copy of these slides, I hope, after this. I just wanted to show the 2 main types of annual return form. The ones that we most typically see are the EMI one, which I'll bring up first. I'm just going to show you the link to the government site so we can have a look at it. Right, so hopefully everyone can see this. This is the page that you'll come to on the government website, and it says EMI end of year return template and guidance notes. So Hmrc do try and produce guidance notes. They're quite lengthy, but they do tend to answer most questions. So I would encourage you to go here as a first port of call. But let's have a look at the end of year templates. And hopefully, again, this is something that I can share with you. Do let me know if there's any problems with this. I'm just waiting for this to load up. Right, okay, so can everybody see that? I hopefully you can. There are different tabs on the annual return. So you'll see they're along here at the bottom. So this is an adjustment of options page. This is a replacement of options page. This is options released, lapsed or cancelled, non-taxable exercise, and taxable exercise. So I'm just going to briefly explain what these mean. The first thing to make sure that you understand is you don't have to fill out every one of these tabs. You just fill out the tab that is required. So for what's happened in that tax year. So this is the 6th of July. That's looking at the tax year that has just passed. So the UK tax year runs from the 6th of April to the 5th of April. So the 6th of July 2021 is looking at ERS events that happened in the tax year 2020 to 2021. So it's looking back. Now, apart from EMI, where I mentioned that very specific step about notifying Hmrc separately, everything else generally goes on this form. So adjustments. Now, this is an important one. This might be a tab that's rarely filled out. It's important to note an adjustment of options isn't when other options have been granted. So some people think, I've got to say there's an adjustment to my options because some more options are granted in the current tax year. That's not counted as an adjustment for HMRC purposes. They're more looking at if there's been a corporate event that maybe has affected the value of the underlying shares. It's not about the options themselves. Now, replaced, we have a Q&A. Let me see if I can help. Hi, Mark. I'm about to get onto that about family arrangements. So I will answer that shortly, but it's a good question. It's on an upcoming slide. So hopefully let me know if that answers your question when we get to it. So replaced options. So this could be in a company reorganization. So again, this is quite specific. And unless you've had a specific corporate event, again, I wouldn't normally see this page being filled out. This may be if your company's been acquired by another company and replacement options are given over the shares in that new company. So as a rule of thumb, the adjustments page and the replacements page are only used if there's been a big corporate activity like a change of control in the company. And this third tab is used a little bit more. Options released, lapsed or cancelled. So this is where you typically see if you have an employee and they've left employment and so you've cancelled their option. So a lot of EMI option plans will say, to the extent that you leave the business as a bad leaver, for example, you'll have to, your option will lapse. It means they've never reached the point where they've converted it into a share. This is just for the option and it will be cancelled. Essentially, the option contract will be ripped up. This is where you report that. And that's the most typical time that we see this page being used. Okay, non-taxable exercise of options. This is where you report the exercise of your options if everything's working for EMI. It's non-taxable because under EMI, there shouldn't be any tax. So this is the most used tab probably on the annual return for EMI, which is when you are having people exercising the option. So that's when they say, I want to convert my option into a share. They give their exercise notice to the company, they pay the exercise price, and then they're awarded the underlying shares. There shouldn't be any tax on that if EMI is working properly and it all qualifies. So that's the page where you do this. The next tab, the final tab, is taxable exercise of options. So this is a page that you typically wouldn't want to fill out in an ideal world because this means something's gone wrong. This means that, well, not necessarily gone wrong. It's either that the company doesn't qualify anymore, somebody's fallen out of the qualifying conditions as an individual, or the exercise price wasn't correctly stated, or it wasn't at the value that HMRC agreed. For all these reasons, there may be tax on the EMI option, and so that's where you put this in. Another very common reason why an EMI option might be taxable is if somebody leaves employment and is allowed to keep their EMI option and they don't exercise it within 90 days. So this is actually in part of the legislation for EMI, that if you leave employment, you have 90 days, that's 90 days, to be able to exercise that option and it's still non-taxable. After that date, if you allow an employee to keep an EMI option and they've left employment after those 90 days, they can still have it, but it won't be EMI tax wrapper anymore. It will be taxable. And that again is where you put this. So I hope that helps with the EMI form, just to give you that background. I'm now going to move on to the template for other arrangements, which I mentioned before is anything other than EMI, etc. And the one we most typically see is growth shares for this with our clients. Let me just see if I can bring this up okay. Okay, so this is the page that you'll see. Again, it looks similar, but as you'll see, it says other ERS schemes and arrangements. I've just, sorry, got an anonymous question. So where do you report new or additional EMI options? So that's the notification of grant that I mentioned. So every time you grant an EMI option, you have to make sure once you've registered your EMI plan at the start, that's registered. But under that plan, various events will happen over the course of the company's life. Every time you grant a new or additional EMI option, That's the notification page, which I mentioned earlier in my talk, which is a separate registration requirement with HMRC. So if we look at it, that for EMI, you have 3 steps. You have the registration of the plan, you have the notification, and that's within 92 days of the grant of the option, of the EMI option to HMRC, and then you have the annual reporting requirement. Whereas for anything other than EMI, you have the registration up front, and then you have the annual return obligations. So EMI is that extra step that's crucial, which is within 92 days. I hope that answers that. So other ERS schemes. So again, this is what you'll see, it looks similar. And again, there's guidance notes, technical notes, and guidance notes, which again, I'd urge you to look at that HMRC walk you through. But again, just to give you an idea of the templates. And as I said, this is typically, I see this used mainly for growth shares and for what we used to call unapproved options, so non-tax advantaged options. So hopefully that's come up okay. So you'll see it says other ERS schemes. So there are a few more tabs here, but this is where you put your grant. So unlike the EMI form, where we had to do the notification separately, for this, you just wait till the annual return date was 6th of July, and anything that was granted in that tax year, previous tax year, will go down here. So you'll see these tabs along here. So other options, events. So that's the first one's the grants. These are, for example, the lapse. So my example for EMI applies here. If somebody's left your employment and you've said that that means their option lapses, that's where you put this here. Notice this says option events. So this isn't where you put something for growth shares. This is options. So this would be your typical unapproved or non-tax advantaged, as they're now called, options. Other acquisition. So acquisition securities. So this is where you put your growth shares, for example. This is other acquisitions. This is acquisition of shares. This isn't options. So you go through here. Now, one point to note, and it would have been on the EMI one as well, is here, column 3, 8-digit scheme reference number. This is why you have to register your plan first to be able to do your annual return required reporting. This scheme reference number is what's generated when you first register the plan. So you just have to be careful about the order that you take your steps in. I can see some more questions coming in. I'm just going to finish talking about this form, and then I'll come back to see if I can answer those now or whether I'll come back afterwards. I just want to show you other restricted securities post-acquisition events. So these are, for example, if there have been any adjustments in the year, if they were subject to restrictions. So if you see here in column L, the lifting of restrictions, so this is an important one, say, for growth shares. I don't know if anybody who tuned into my last webinar on growth shares, and I talked about hurdles. So if a hurdle's been hit, the restrictions on those shares fall away. That's where you put it. So you can see there's quite a lot to think about with these forms, which is why people do struggle with the reporting requirements. But obviously that is something here that we can help at. It's impossible to cover every scenario on this webinar, but hopefully it's showing you that the things that you do need to think about. Now, I'm just going to go back into the, here we go, into our slides. I just want to take you into the next bit, which is just a little bit more about the annual return. This first bullet point is important. You must file every year, even if there's no reportable events. So let's take an example of, you might have an EMI plan that's been around for a few years. You can have made new grants, because remember, that's that extra notification step. But within that year, no one's exercised their options because they haven't vested. It might be an exit-only plan, or people haven't been around long enough to convert that right. Nobody's left, so there's no lapses. Nothing else has been going on. So it's just been a quiet year in your share plans. You still have to file a return. albeit it's what we call a nil return. Now, you don't have to go in and fill all those tabs out, because I said before, you only fill out what's necessary, but you'll see at the back of the form, there'll be a little box to tick that says nil return. So that's very important to note, that if you have a share plan, as long as it's active, you still have to file a return each year. Now, Hmrc aren't going to remind you of this. There are no notifications from them reminding you about these obligations. We as a professional services firm obviously remind our clients, as do most, but Hmrc won't be coming to you about this. So the onus is on the company, and if they employ their advisors, to make sure that this happens. Now, reportable events, I did kind of go through these when I showed you the actual forms themselves, but just to say again, the typical ones are if an option's been exercised, if something lapses, again, mainly because somebody's gone to, either left their job or they haven't hit certain performance targets. Certain shares and options are not just they don't lapse just because somebody leaves. They might have a condition, which is a performance condition, either an individual one or a company profit level target, and that might not have been hit that year, in which case that may mean that the whole of the option or a portion of that option lapses. And that's another thing to note. Even if it's a portion of the option, that needs to be reported. So you might have given somebody an option to acquire 100 shares, and it might have lapsed as to 20 of them. So 20% of that lapses because that year hasn't hit the targets. We have to go in and report about those 20 shares representing 20% of that option, even though they would still be a remaining option as to 80%. Cancellations, as I've mentioned as well. This is an interesting one, a value shift. So this is veering into corporate territory, but if you've had a company share buyback, which is something again that we advise on here, where you might want to buy out a shareholder, the company buys back the shares and then they're cancelled. That means there's an uplift in the value of the shares for the remaining shareholders. If one of those shareholders is an employee shareholder, then that raise in value represents a reportable event. So as you can see, there's quite a lot to consider with these reportable events. And then I've said there, the extra step for the unapproved options is you have to mention the grant as well, as opposed to EMI where you don't. Right, I'm just going to take this opportunity to look at some more of these Q&As. Okay, Heather, thank you for this question. This is a good one. This is saying, when filing the reporting, do you also need to add co-founder shares in that reporting or only employees? Now, if you're a founder shareholder and you're an employed director, then technically that should go on the ERS annual return. It's an area that Hmrc is involved in. It used to be seen that founder shares were not necessary in this requirement, but we always say it's better to be safe than sorry. And if you're an employed director and you have co-founder shares, and technically you should probably put it on an ERS return if you have a share plan already. I wouldn't say that it's necessary if you don't operate a share plan. It's a tough one, Heather. I'd say we'd probably need to look and see if there was value attributable to those shares to start with, and it's probably on a case-by-case basis. Khalid, is there any forms? Okay, so Khalid, your question is very similar to the first question, which is about family gifts to a family member. Now, I'm about to come on to that, so hopefully I answer this question with my next slide. So, what is not reportable? And the first point here is a question that's arisen from a couple of you, which is shares and options transferred in the normal course of the family, domestic, or personal circumstances. Now, this can get a little bit messy where those people are also employed in your business. And this is something that we say that we should look at on a case-by-case basis. If you're genuinely transferring shares or options to a family member, then that would not be reportable. However, if that family member is also employed in business, then it's a question of fact as to why are they really receiving those shares. It might be quite a tough argument to say that they're getting shares in a business that they're working in, and that's got nothing to do with their employment status, rather the personal relationship one. So I'd say it's quite a grey area. But if it's genuinely a non-employee, then it should be absolutely fine, and you shouldn't need to report on the form. What I should also say is, for those that are wondering, when we're talking about the ERS return, it did used to be called a Form 42, and that might be something that people recognise. It's no longer called a Form 42, but this is the new name. Oh, apologies, I've just skipped there. So the other times it's not reportable is if shares are acquired independently by employees. So if somebody is acquiring other shares, it's not to do with your company, and they've independently acquired them in another business, that's not a reportable event for you. We're talking about where employees hold shares in your business. That might be something that the employee has to look at with the other company that they're holding shares in, but it's not something that you have to worry about. Certain bonus issues, excuse me, aren't reportable either, and share for share exchange. So if you're having a reconstruction of your company or a group where you're swapping shares, so the new shares sit in the shoes of the old shares, that wouldn't be considered a reportable event either. I hope that you can see from this that there are quite a lot of things to think about, and this is just a snapshot, but hopefully it gets you thinking. Now, what is the purpose of all this for Hmrc? They're not trying to give you a lot of hard work for nothing and fill out these rather complex forms. What they're trying to do is assess if there's any PAYE or national insurance payable that hasn't been paid. This is a bit about the correlation between the different areas of payroll, corporation tax that I mentioned earlier. They're looking to marry up what you're reporting with what you're doing with your PAYE, for example. So if you're reporting that you've got options that have lapsed, then they will be looking, and they won't expect any tax to be coming off anybody in that scenario for PAYE. If you've reported unapproved options that are fully taxable, they'll be expecting to see that that tax is being applied correctly. Hmrc can impose some pretty terrible high tax penalties if PAYE is not dealt with properly. Again, that's a subject for another day, but it's just very important to try and be as accurate as possible, because they will be looking to see whether everything ties up. Now, as a final point, I just wanted to talk about closing a scheme. So this is all very well whilst we are operating our share plans, but some of these have a lifespan. Most of them have a lifespan around 10 years, but you also may close your plan earlier than that. You may have done what you've achieved with it and you want to shut your plan. I'm afraid that's not the end of the reporting. Once you close your scheme, that's another reporting event that you need to do to Hmrc, not on the annual return itself, but you have to notify them, and that's a separate process. And then importantly, you file a nil return for the tax year of closure. So that's one last annual return that has to be done. And that's again an area that some people don't realise or forget about. My final point is take screenshots as evidence. Unfortunately, this system doesn't allow you to save your forms once you've done them, or if it does, it's quite a difficult one. And most of my clients that I see don't have saved forms. And helpfully, Hmrc doesn't give you a copy of the form that you filed either online. So the way that everyone adapts to this is to take screenshots. Now, these are a common request in tax due diligence. So if you're looking to sell your company, or you're having an investor come in and they're looking at the due diligence on the company, one of the things that they might well ask for is evidence that you have completed all your reporting requirements to Hmrc on any share plans that you operate in a timely manner. If you can't produce evidence of that, then they may look to bargain chip what they're offering for the company, because you can't actually produce evidence to justify that you did do it. So we'd always say, just take screenshots as much as you can. I realise it's not ideal, but it's the best that we've got at the moment until they change their system. So that is everything for now. We've finished slightly early. I can see that there are a couple of questions here that I'm going to come back on independently, but I thank you very much for your time. I hope you found that useful. My contact details are here at the end. Please do feel free to get in touch. We are here to help you. And as I said, this is my area of specialism, and it is getting into reporting season. So hopefully the one takeaway from this is start sooner rather than later. Okay, thanks everybody. Thank you very much. Bye-bye.